distinguished guests, faculty, students, and friends. My name is Catherine Fang, Master of Ceremonies. Today we commemorate the 237th anniversary of the United States Constitution. In doing so, it is an honor to welcome Mr. Kurt Levy, President of the Committee for Affirmative Action on Trial, focusing on the recently decided Students for Fair Admissions v. Harvard and University of North Carolina decision. If you are interested, a recording of this program will be shown in the Tepfer room of Adelbert Hall tomorrow at 11:30 a.m. After this replay, Rob Solomon, the University Vice President for Diversity, Equity, and Inclusion will comment on and take questions about the affirmative action issue. A registration link for Tuesday's event was in Friday's Case Daily. Lunch will be provided for registered participants. The Society for Constitutional Policy members appreciate your time to share thoughts on the questions from the panelists and the audience. Please allow me to introduce the panelists, Ms. Sophie Dasco, Mr. Christopher Batarse, and Ms. Lauren Hodge. Now please join me in welcoming our moderator, Ms. Hannah Bolander.
Thank you, Ms. Fang. Ladies and gentlemen, as Ms. Fang mentioned, we're here today to discuss the Supreme Court case Students for Fair Admission versus Harvard and its impact on race-based college admission. The recent ruling has fundamentally altered the legal landscape of affirmative action policies in higher education, making a pivotal moment in the ongoing debate over diversity, equity, and inclusion, and fairness in admissions processes. Affirmative action in the United States was rooted in the civil rights movements of the 1960s, designed to promote opportunities for historically underrepresented groups in education and employment. Over the years, key Supreme Court cases, such as the University of California v. Bakke, 1978, and Grutter v. Bollinger, 2003, upheld the use of race as a factor in admissions, arguing that fostering a diverse student body was a compelling government interest. However, in 2014, the organization Students for Fair Admissions, SFFA, filed lawsuits against Harvard University and the University of North Carolina, alleging that their race-conscious admissions policies discriminated against Asian American students and applicants. SFFA contended that such policies violated the Equal Protection Clause of the 14th Amendment, which guarantees equal treatment under the law. On June 29, 2023, the Supreme Court issued a 6-3 decision in SFFA v. Harvard, effectively overturning decades of precedent and ruling that race-based affirmative action in college admission violates the Equal Protection Clause of the 14th Amendment. Chief Justice John Roberts, writing for the majority, argued that doing so contradicts the Constitution's principle of equal treatment for all individuals. This decision has sparked intense reactions across the country. Proponents of the ruling argue that it upholds fairness and meritocracy, ensuring that all students are judged based on their qualifications rather than race. Opponents contend that it ignores the historical and systemic disadvantages faced by racial minorities and undermines efforts to promote diversity in higher education. Today, with the help of our esteemed guest speakers, we will examine the legal, social, and educational ramifications of this historic ruling. What does the future hold for diversity in college admissions? How will universities adapt to these changes? And what role should the courts play in shaping the policies of educational institutions? Mr. Levy and Professor Enton will each have 10 minutes for opening statements. Mr. Levy, the floor is yours.
Thank you. Is the sound okay?
Yes, good, thank you.
Great. Let me start with some background. 2 decades ago, when I was at the Center for Individual Rights in DC, that's a public interest law firm, we represented the plaintiffs in the University of Michigan affirmative action cases, which Hannah referred to, Gratz and Grutter. Really similar to the SFFA case against Harvard and UNC, in that we were challenging the use of race-based admissions. In this case, 2 cases were both at University of Michigan, their undergraduate college, and their law school. And our aim was to, end the explicit use of race in admissions, but the Supreme Court ruled otherwise in Grutter in 2003. And then basically 20 years later, June of last year, the Supreme Court corrected what I believe was a mistake in 2003. Most of you are too young to remember the Gratz and Grutter decision, so let me just briefly go over those. We lost the law school case, the Grutter case, and we won the college case, but can't really say it was 50-50. It was mostly a loss because in Grutter, the Supreme Court reinforced what they had said less decisively in a divided opinion in 1978 in Bakke v. University of California. And what they said was that the educational benefits of broad-based diversity were a compelling interests that could justify at least the modest, narrowly tailored use of race in admissions. What came to be known as the diversity rationale. We're also used to that term diversity, but it really, at least as a way to refer to racial diversity, was something that happened, after the Bakke decision, starting in the 80s. Now you might say, well, why do you even need a compelling interest? Well, that's because the Constitution and Title VI prohibit racial discrimination by, they both for state universities and just Title VI for private universities, and the schools don't deny that they're discriminating, that is, treating some races differently than other races. Now, when I say Supreme Court in Bakke and Grutter said that you could have a modest use of race, the Supreme Court was talking about using race as one of many factors to achieve broad-based diversity, so much as you would use what state you're from, your extracurricular interests, things like that. But in any case, because of the decision in Grutter, the diversity rationale remained the governing legal, if not cultural, justification for another 20 years, that is until last year. So you might say, how can the educational benefits of diversity, which research shows are modest at best, qualify as compelling enough to justify something, as clearly prohibited by the Constitution as racial discrimination? I mean, the legal answers the court said so. There were a variety of rationales available, and that's the one that the court sort of chose in Bakke and decisively chose in Grutter. I think the political answer, frankly, is that it's easier to sell discrimination against certain groups if you say it benefits everyone. It's educational benefits for everyone. Now, I know I can only speak for the Center for Individual Rights, but I know that had race really been used in the way it was discussed in Bakke, just as one of many diversity factors, people would have barely noticed, no less, invested all that time and energy into challenging it. And I know the same is true of my friend Ed Bloom, who organized students for fair admissions. I know he's also said to me, no one would object if it was, if it was one of many diversity factors. But race was instead a huge factor, at the most competitive schools at least. When we sued University of Michigan, they were giving you 20 points for being Black or Hispanic. No points for being Asian or Arab American, but certainly for being Black or Hispanic. And that was equivalent to the difference between an A and a B average. So, we're talking, a huge difference, or as measured by standard deviations at the law school, where they didn't have the point system, even more than a standard deviation. But that all, at least the use of the diversity rationale came to an end last year. And, excuse me here. Now, I think we're better off without the diversity rationale because it was always disingenuous. I remember when I, 20 years ago now, spoke at Harvard about the Gratz and Grutter decisions, and it was a huge panel. I think it was 9 people, and I was the only one who was, against race-based admissions. And, I turned to my fellow panelists and I said, how many of you think that the educational benefits of diversity are the real reason that we need racial preferences? And only one did. I remember he was a professor at the education school, so none of the lawyers on the panel thought so. But they all thought that we needed diversity, racial diversity, for its own sake, not because it helps, white or Asian kids get a better education. But the Supreme Court had been clear that you can't use race-based admissions just to achieve racial balancing, essentially a quota. So hence we wound up with the diversity rationale for 45 years. I want to focus on a few, we certainly don't have time to go over the whole opinion, but focus on a few aspects of it that really stick in my mind. Grutter had said that for preferences to be constitutional, they have to be limited in time. And it said, we don't expect that schools will need preferences for more than another 25 years. And people debated to what extent is that dicta, to what extent is it a holding. But in any case, the court in SFFA said 20 years later, the end is nowhere in sight, and pointed out that the defendants couldn't even articulate, beyond hand-waving when it would come to an end. And that's because the diversity rationale, unlike remedial justifications, which, by the way, are still constitutional, a school can still say, we don't have enough minorities because we discriminate against minorities. But remedial rationale comes to its end when, the disparity caused by the discrimination is over. There's no such thing for the diversity rationale. And another thing that sticks in my mind is that the Supreme Court pointed out that these schools were just lumping everyone together within these very broad-based categories. They, within a few racial categories, that there was really, they were treating the members of each group as if they were interchangeable, rather than as individuals. School also said a couple of things to which it sort of replied, how stupid do you think we are? Not in those exact words. One was that schools were not engaging in a quota, and it pointed out that they had, virtually identical percentage of each minority group from year to year, and then it said something similar about the school's claim that we don't use race against anyone. Certain groups get a preference, but no group is disadvantaged by it. And again, the Supreme Court basically said, how dumb do you think we are? But it did end with a little bit of a loophole. It said, the Roberts opinion, that is, said nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life, be it through discrimination, inspiration, or otherwise. Now, conservatives have criticized Roberts for putting that in there, but the SFFA brief said the same thing, so it's probably not a fair criticism. And Roberts did add that despite the dissent's assertion to the contrary, universities may not simply establish through application essays or other means the regime we hold unlawful today. What cannot be done directly cannot be done indirectly. In other words, don't cheat. A couple of things the decision didn't do. It didn't end all affirmative action. The decision doesn't in any way prohibit and leaves the door open for affirmative action based on other types of disadvantage, educational, socioeconomic, or really any type of disadvantage. It didn't really end affirmative action in general because it really only applies to admissions, arguably just higher education. So in contracting or employment, you can still use preferences. We'll see what how the lower courts and maybe eventually the Supreme Court applies it to those areas, but for now, it's really limited to higher education admissions. And I suspect that, the use of race-neutral alternatives is the reason that you haven't seen a big drop in minority enrollment. I know at Harvard, they just recently reported that it had dropped from 2018, black students had dropped from 18% to 14%. I'll point out that 14% is still more than the proportion of black folks in the American population. The number of Hispanics had gone up from 14 to 16%. At Yale, there was no change in the percentage of black and Hispanic students. And at UNC, the other defendant in the case, it was down, number of black students were down a little bit, but from about 10.5% to 18%. Schools resisted race-neutral alternatives for as long as they could. They really hated the idea. They claimed it didn't work, but that they don't work in restoring racial diversity, but that had been disproved 20 years earlier when California outlawed racial preferences at state schools. University of Michigan did. Texas did because of a Hopwood, which was eventually overturned by Grutter. But all those states had been able to restore pretty much the same level of minority enrollment using race-neutral alternatives. And then also the schools basically said that they wanted to remain elite. I mean, what they basically were saying was, we don't want to relax our standards for all races. We're willing to do it for a couple of races, but we're not willing to do it for everyone. I see my time is up, so I'll just say that I think opponents of race-based admissions are going to have their hands full to make sure that race-neutral alternatives are used in a sincere way and not just used, as Robert said, to accomplish what this decision forbids.
All right. Thank you, Mr. Levy. Professor Enton, the floor is now yours.
Thank you, and thank you for having invited me to be on the program. I've been on several earlier ones, and I know the standard that you've set, and I hope I will get close to it. Now, before students for fair admissions, the SSFA decision from the Supreme Court, there was a pretty lively debate about the constitutionality of race-based affirmative action in higher education that Mr. Levy has nicely summarized for us. This is a debate that applied not only in higher education, but also in elementary and secondary schools. And just to build on a point that Mr. Levy made, the Constitution applies to public institutions, but not to private institutions. Title VI of the Civil Rights Act of 1964, which prohibits racial discrimination in federally assisted programs, does apply to private institutions like Harvard and Case Western Reserve University. We could also talk about the ramifications of the SSFA decision beyond higher education, because Edward Bloom and other folks who opposed affirmative action in higher education have now begun to litigate other kinds of DEI initiatives in the private sector, but that's a subject for another day. But I think it's clear that some folks at least are taking the Supreme Court's ruling as a kind of a beacon for where to go from here. I don't want to get too bogged down in history either, but long before we started having debates about affirmative action, there was a fair amount of discussion about exactly what was problematic about racial discrimination in a constitutional sense. And I think we can see a couple of different strands of this approach in just the first Justice Harlan's famous dissent in Plessy against Ferguson. Most people remember that Justice Harlan said, "Our Constitution is colorblind and neither knows nor tolerates classes among the citizens." Now, on that view, race is always and everywhere an illegitimate basis for policymaking. But in a number of places in the opinion, Justice Harlan suggested a different kind of concern. And I think he got it most strikingly in this passage. This is a case about segregated railroad cars in Louisiana. And Justice Harlan says, "Everyone knows that the statute in question had its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks, as to exclude colored people from coaches occupied by or assigned to white persons. And then he said, no one would be so wanting in candor as to assert the contrary. Now, if that's the problem, and Justice Harlan didn't have to resolve that in the Plessy case, but if that's the problem, that suggests that perhaps for some purposes, race might be a permissible basis for making policy to the extent that the goal is to provide assistance to traditionally disfavored groups. Now, in other circumstances, we could have a nice involved debate about which is preferable as a matter of policy, as a matter of constitutional interpretation. But I agree with Mr. Levy. For the short term, at least, the Supreme Court has essentially resolved the constitutional question. And so I think there are a couple of things that I want to say about this. One is that the SSFA decision does not invoke originalist grounds for rejecting the constitutionality of affirmative action. The only opinion in the case that does invoke originalist grounds is Justice Thomas's concurrence. That was, as far as I can tell, the first time that even Justice Thomas had relied primarily on originalism in an affirmative action case. It's also worth noting that nobody else has joined that opinion. Now, that doesn't mean that he's wrong. It just means that at least the rationale here is not purely originalist. Now, I think what we ought to be thinking about now is what follows from what the Supreme Court has done. We might consider whether the whole affirmative action debate should have turned exclusively on the diversity rationale, but that may be a legal artifact of what Justice Powell said in his controlling opinion in Bakke. Instead, let's try to figure out what exactly the Supreme Court has told us so that we can think about what universities might lawfully do going forward. Now, two key statements in Chief Justice Roberts' opinion that we should focus on. One is eliminating racial discrimination means eliminating all of it. If that's the principle, then presumably the court is endorsing colorblindness because race is not a permissible basis for decision making. But the very next paragraph says any exception to the Constitution's demand for equal protection must survive a daunting two-step examination known as strict scrutiny. Now, there's some tension between these statements. If the Constitution is colorblind, then why do we need to talk about exceptions? Now, this suggests, as Mr. Levy indicated, that the court has left open the possibility of some, unclear exactly how much, some consideration of race in some circumstances. And in part 6 of the opinion, the last substantive part of the opinion, Chief Justice Roberts offered some clues. He said, universities are not prohibited from considering an applicant's discussion of how race has affected his or her life, be it through discrimination, inspiration, or otherwise. But universities can't, as Mr. Levy indicated, they can't simply maintain what the court condemned as consideration of race qua race in personal statements or otherwise. Any consideration of race must be tied to that student's courage and determination, or that student's unique ability to contribute to the university. Bottom line, the student must be treated based on his or her experience as an individual, not on the basis of race. Now, these statements do not eliminate the possibility of legal challenges going forward. And so let's think about where we might we might go. How can we tell how courageous an applicant is, or how much determination the applicant shows, or how uniquely the applicant can contribute to the university? Part of the plaintiff's argument in SFFA was that admissions officers showed bias against Asian applicants on subjective factors that, like personality, right? So if the demographic composition of entering classes remains similar, then critics may well suggest, as Mr. Levy indicated, that maybe the universities are cheating or trying to get around the Supreme Court's decision. So we'll see. Indeed, I think to the extent that critics of affirmative action have been suggesting that universities have been admitting less qualified applicants through affirmative action, that we should expect them to be looking quite closely at the demographic composition of entering classes. But beyond personal statements, the Supreme Court didn't really tell us very much about other practices. So let me just raise some questions for us to think about. What counts as race neutral? Some states, Texas and Florida, for example, say if you rank high enough in your high school graduating class, you're automatically admitted to a state university. Now the percentage varies. I think in Texas it's 10%, in Florida it's 20%. But these programs do promote a degree of diversity, but they promote that diversity because there is a high degree of residential segregation such that we have plainly predominantly black or Latino high schools, predominantly white high schools, predominantly others. And the folks who designed these programs know that. So we might ask, is this kind of program race neutral? Now, beyond percentage programs, what about targeting recruiting efforts to predominantly minority schools? At what point does that cross the line from race neutral into maybe racially biased? I don't know. If the Constitution is colorblind, which again the court didn't say, does the admissions office have to review all the applications in a blind fashion so that it has no information about the race of the applicants? That may seem like a hypothetical, but some years ago, at a previous Constitution Day program, Ward Connerly, a notable affirmative action critic, said just that. A couple more questions. At a time when women represent a disproportionate share of college and university students, would it be constitutionally permissible for universities to give a plus to male applicants? And if so, if that's permissible, why is that somehow less problematic than affirmative action based on race? What about legacy preferences, which traditionally have favored affluent whites? I don't have fully formed answers to these questions. I think that a lot of the debate about affirmative action might actually sensibly unfold as a policy matter as much as a constitutional matter. I don't have firmly developed answers to some of those questions either, but I hope that we can get into some of these issues over the course of the remainder of our program. Thanks.
Thank you, Professor Enton. We will now proceed with questions from our panelists. Professor Enton and Mr. Levy, you each have 5 minutes to address the question directed to you, 3 minutes to respond to the other speaker's points, and finally, 2 minutes to defend your original argument. I would like to invite Ms. Dasko to ask her first question.
Mr. Levy, the SFFA ruling has been celebrated by those who advocate for a meritocratic admissions system. How do you respond to concerns that focusing solely on academic metrics disadvantages underprivileged students?
Well, the SFFA decision doesn't say that you have to focus on merit. It just says that you can't use race. So if you wanted to pick, just randomly pick students, I mean, you would wind up with, pretty much the same proportion in the admitted class that you have among the applicants. But schools don't want to do that. What they really want is the best of both worlds. They want to be able to give preferences to certain minority groups, but not have to lower their standards in general. And certainly the SFFA decision does not say that you have to focus narrowly on academic criteria. You could get rid of the use of standardized tests at all. You could get rid of the use of grades. I mean, if you wanted to base it on other factors. Now, that wouldn't necessarily be fair. If you remember at the, one of the problems at Harvard was that Asian students tended to score much lower on the personal rating, which is not quite the same as personality, but if you read the definition of it, it's awfully close. And Harvard had no problem saying, look, we have found that Asian kids just don't deserve as high a personal rating. So, there's room for what some would call reverse discrimination to sneak in anyway. I don't know if I missed part of your question, but I certainly am all for the use of broad-based affirmative action in which we look at all types of disadvantage. Again, socioeconomic, educational. Neither of my parents went to college, and I always felt, at least at the beginning of my college experience, that that I was at a disadvantage. But life is not a completely level playing field. I'm sure I had advantages. I had at least a mother who, despite never having gone to college, was determined that her children would go to college. So, and not everyone has, parents who believe in them in that way. So, look, we all have disadvantages in life, but part of being successful in life is succeeding despite them.
Thank you. Professor Enton, your response?
This gets into a question about what do we have admissions offices for and what are their criteria. There are universities that established geographic criteria for admission. And I'm not talking about public universities where there's a premium on being an in-state resident and in-state residents get a tuition break compared to out-of-state residents. I'm talking about other kinds of geographic diversity claims. And there's some pretty good evidence historically that that at places like Columbia and the University of Wisconsin, for example, geographic diversity was a kind of a pretext for anti-Semitism. That there were a lot of disproportionate number of Jewish applicants coming from New York, and they scored well on the traditional academic criteria, and so the concern was maybe if we could spread the demography or the geography of the student body, we might get fewer Jews without actually having a firm quota or a total ban. But if we're going to have admissions offices and they're going to make decisions, the rationale for considering race in admissions decision is that the United States has a long and deplorable history of racial discrimination. And I don't want to, not only because we're time limited, I think we all understand that. And the idea that the most egregious piece of our history is somehow constitutionally out of bounds strikes me as at least a little bit perverse. And let me just pick up on the comment or the question I raised earlier. If in fact universities are going to give a plus to male applicants because the student bodies, at least in some fields, are disproportionately female, then the beneficiaries of those preferences are from the gender that has traditionally been powerful and privileged. If it is easier to justify a gender-based preference in admissions rather than a race-based preference, I think that kind of ignores some of our history. So, as I said, I'm not uniformly enthusiastic about the expertise of admissions offices, but if we're going to have them, it seems to me that treating race as particularly problematic is not intuitively, obviously correct to me.
Thank you, Professor Enton. Mr. Levy, a response?
I certainly have no problem with geographic preferences. That's exactly the sort of race-neutral alternative that would actually give us more true broad-based diversity. Now, not all of my colleagues, who oppose racial preferences would agree with me. As a matter of fact, this is K through 12, not higher education, but the Pacific Legal Foundation challenged the geographic preferences at the Thomas Jefferson Magnet School near where I live in Virginia, because the record indicated that they were doing it just as basically a way to achieve racial diversity. And I'd say, it's probably split down the middle among my colleagues about who thinks it's okay anyway, but I don't think the Supreme Court or the lower courts are going to strike that down. I think that's, again, we can sort of talk about a perfect world in which, you would have to really believe that geographic diversity was genuine and you're not just using it as a proxy. But I think in the real world, courts are not going to strike that down. And also your point about Jews, not only can geographic preferences be used to, implicitly discriminate against Jews, but about 100 years ago, there really were Jewish quotas at the top schools. And they basically made the diversity argument, is we don't want, 30% of our student body to be Jewish if only a few percent of the population is. As for the argument about, discriminating based on gender, look, the Supreme Court sets a higher bar for race. It sets some type of intermediate scrutiny for gender, and of course there's no prohibition on legacy preferences under the Constitution or, arguably under Title VI either. But there's a reason that we set the bar high. I think racial preferences are particularly dangerous. I mean, in this case, you're putting either educators or the courts in charge of saying which races is it okay to discriminate against. And at any given time, there'll be ones that are favored and they aren't. But, again, I point to the history of Jews.
Thank you. All right, I will ask Mr. Batarse to ask his first question.
Professor Enton, some argue that socioeconomic-based admissions policies could be an alternative to race-based admissions. Do you think this is a viable solution, or does it fail to address the full scope of racial disparities in education?
Well, if we were having this discussion before SSFA, I would have gotten into a lot more detail about a response to this question. But we're not talking before SFFA, we're talking afterwards. And so at this point, whether class-based affirmative action is more effective or less effective than race-based affirmative action is a nice academic sort of discussion, and there are certainly people out there who have been researching that. But in the real world, the question isn't now, is class-based affirmative action preferable on some ground to race-based affirmative action? Is it permissible? And I think nothing in the Supreme Court's decision, nothing in any of the opinions in the case calls that into question. Whether class-based affirmative action would be as effective, I think, is an empirical question. I know I was a demographer before I became a lawyer. I know a little bit about how you do that kind of research, but I haven't done things like that in a long time, so I don't really feel comfortable weighing in much detail on that. To the extent that race is off the table, and Mr. Levy is right, the Supreme Court has essentially said that the colorblind notion is a stronger view of equal protection than the anti-subordination view, whatever, as I said, whatever we might say about that as an intellectual matter, I think given that race-based affirmative action in higher education is now off the table, class-based affirmative action strikes me as an appropriate thing to do, and I think it was an appropriate thing to do whether you had race-based affirmative action or not. How well it will work, that, as I said, that's an empirical question, and I'm not in the prediction business, so I will let it go at that.
Thank you. Mr. Levy?
Yeah, I mean, I agree with you. Socioeconomic or educational preferences, really any kind of race-neutral disadvantage should have always been on the table. And the fact that schools have to be led kicking and screaming into that, I think, is a shame. And I think it really, is because of, what Justice Thomas said 20 years ago in the University of Michigan decisions, that a lot of this is about aesthetics. Schools just want to be able to say, they want to be able to write down, we have 14%, black students. And they want to do it with compromising their academic standards as little as possible. So of course they're going to go for the, minority kids from affluent, well-educated families. But that's not who people have in mind. I mean, I can tell you from years of debating this, when people talk about the need for affirmative action, they usually reference, poor kids in impoverished areas, not, affluent black kids. Well, let me not, probably don't have time to go into this, but I think that socioeconomic and other types of disadvantage-based preferences have been proved effective. Again, for 20 years, you haven't been able to use preferences in Michigan, Texas, California, which all have some very competitive schools that used to use it heavily. And the numbers bounced back up really quickly. Again, schools don't want to do it. They'll argue that it's not effective, which I think has been disproved, or that they want to remain elite. They don't want to lower their standards for everyone. But, I think everyone supports the idea that the poor kid should get, or the kid who, whose parents are not educationally privileged should get some sort of preference. And, my parents didn't go to college. And like I said, I always felt like that was at least a small disadvantage for me. I guess I'll stop there.
Thank you. Professor Enton?
Selective universities have a pretty dreadful track record on economic diversity. There are prestigious selective institutions where there are more students from families in the upper less than 1% of the income distribution than in the bottom 40% or more. We're not, I hope we're not going to try to create a trade-off between the less affluent and the people of color. There is some overlap in that there, but it's not completely so. I think one criticism of affirmative action that I have not heard here that might be worth thinking about is something that we saw in the political arena. When Vice President Harris was nominated, she was dismissed as a DEI candidate who hadn't gotten there on the merits. And some of the criticism of affirmative action in higher education suggests that somehow the beneficiaries of affirmative action aren't good enough or aren't qualified. Now, I've been teaching for 40 years, and I can tell you that I've had thousands of students, and I think it is really troublesome to have people wondering, are these folks actually good enough to do the work? They are. That's been my experience. I'll leave it at that.
Yeah, and I mean, again, to say that people wonder if Black or Hispanic students were admitted under a lower standard is not a knock on Black and Hispanic kids. it's a knock on lowering standards. If we had lower standards for people who were blonde, people would look around the room and say, I wonder if, they were admitted under lowered standards.
I will ask us to move to the next question.
Oh, I'm sorry.
Sorry.
I apologize. I was not paying attention.
Thank you.
Yeah.
Ms. Hobbs, the next question.
Mr. Levy, do you believe that race-conscious admissions policies have done more harm than good when it comes to promoting diversity and equal opportunities in higher education?
I think, let's put the law aside. In the early years of affirmative action, you actually, look, the reason that we're even talking about this is because if you base it just on grades and test scores, there is a disparity. And that disparity narrowed in the early days of affirmative action and then stopped narrowing. And I think the reason is that because in the early days, there really was a non-level playing field. You really, in 1970, you can't say that, the affluent black kid, was really on the same, level as the affluent white kid. And so I think to the extent that you had preferences then, you really were taking real disadvantage into account. But, the people who are getting in, or were getting in under race-based preferences were, decades after that point. And I think once it became really favoritism rather than taking into account true disadvantage, then it didn't serve its purpose anymore. It no longer, was looking at a real remedial problem, and so the gap stopped narrowing. And it's because that gap stopped narrowing that the Supreme Court pointed out there's never going to be an end. There is no end in sight, and that's one of the big reasons why, again, I think if the justices could have convinced themselves that, all right, give it another 15 years and we won't need this anymore, you would have had a very different result. But I think the last 20 years has taught us that there's just the dependence on preferences was not getting any smaller. I also wanted to make reference to the mismatch theory, which was Rick Sanders at UCLA Law School has been the biggest proponent of it, for lack of a better word. But it's the idea that if you admit people on a lower standard, then they're in general not going to perform as well. And again, that would be true if you admit blonde people under a lower standard. And he pointed to the fact that the preferred minorities, blacks and Hispanics, tended to finish on average lower in their class, do less well on graduate school admissions tests, do less well in bar passage. And again, I think that's just obvious. How can you, there's no free lunch. How can you admit people under an admittedly lower standard and then expect them to do exactly the same?
Thank you. Professor Enton?
Well, let me pick up on the Sander point. Just as a point of personal privilege, Rick Sander and I have known each other for a very long time. He actually was here at the law school about 3 or 4 years ago for a day-long program on one of his other projects, which has to do with the law and practice of fair housing. Sanders' argument about mismatch is at least controversial. It has generated a fair amount of debate. I'm not sure how many points the critics have necessarily scored against him, but I think that in some ways the mismatch argument kind of is peripheral to some larger questions. If you get into a selective institution, you gain advantages in that institution that you would not get if you went someplace else, even if you went someplace else and wound up getting higher grades or higher class rank. And so I'm not sure, even if we accept Sanders' work on mismatch, I'm not sure how much weight that should carry when we think about these sorts of questions. I mean, I don't mean they're irrelevant, I just mean that they aren't a gotcha. There may be downsides, and in fact, some folks do not want to go to selective schools because they find aspects of that experience or what they think will be that experience unattractive, and so they go to other places. But we're talking about the Constitution today, and I'm not entirely sure, again, how much constitutional significance mismatch theory has, whatever statistical or policy relevance it might have.
No, I think it has, I'm sorry, it is.
Go ahead,
Okay.
yes.
I think it has moral relevance if you're going to ask certain racial groups to kind of take a hit for you know, in order to remedy discrimination, you know, of past generations, then you should at least be able to argue that it's doing good. You know, that it is that it's not doing as much harm as it is doing good. And you know, along with mismatch theory comes the so-called cascade effect, where it was never the case that affirmative action made higher education more diverse. It was just that minorities arguably would go to a slightly lower ranked school, but overall diversity would be the same because obviously at the bottom there's schools that are not, you know, really competitive at all to get into. You know, I remember when we were litigating the Michigan cases, we were definitely outscored based on amicus briefs, and one of the amicus briefs, maybe there might have even been two, from corporations arguing that, you know, we recruited the top schools and we're not going to be able to recruit minorities if minorities don't go to the top schools. And I always remember thinking, who said you have to just recruit at the top schools? You know, there's another, yes, there are a lot of advantages to going to the top schools because we live in an elitist society. How about having a slightly less elitist society, and maybe we'd be more motivated to do it if the only way we could maintain diversity in corporate America is for them not just to recruit at the top schools.
Thank you, and we will move on to our very last question for the day before we take questions from the audience. I invite Ms. Dasco to ask her second question.
Professor Enton, how would you respond to critics who say that affirmative action policies perpetuate racial divisions rather than reduce them?
It strikes me that there is something to that, but I think the question that we ought to be asking, again, if we're thinking about this in constitutional terms, is why does that matter? In First Amendment law, we have a doctrine called the heckler's veto. That is to say, members of the audience who disapprove of what a speaker is saying don't have a First Amendment right to shut down the speaker. By the same token, it seems to me that if people don't like affirmative action or they don't like racial diversity, that may be politically relevant, but I'm not sure why it should be legally relevant. Now, I want to be clear. You know, I'm a law professor, but for most of my time at this university, I've actually had an appointment in the political science department. So, you know, I'm not one of those people who thinks that the law is a closed logical system. Right? But if you're asking me about what relevance does this have for constitutional analysis, I would say not very much at all. Now, if you're asking me as a policy question, what do we do? Well, politics used to be called the art of the possible. And so opposition is, in that sense, is relevant to how you proceed. You know, but over here over my left shoulder is a photograph of probably our most significant graduate, Fred Gray. Fred Gray represented Rosa Parks when she got arrested on the bus. He represented Dr. King. He played a significant role in 4 landmark Supreme Court decisions in his first 10 years out of law school. He spent a lot of his early career litigating against people like George Wallace. Right? And the idea was there were loads of people who thought that the notion of desegregating public schools was just terrible. Right? But that didn't stop Mr. Gray or the Supreme Court from saying that the law prohibits segregation. So if you're asking me, you know, How does public opinion bear on the legal question? I would say probably not very much. If you're asking me, how should public opinion play when we're talking about what sorts of policies to pursue, then, as I said, I think as a practical matter, you've got to be realistic. But just as I don't think that the heckler gets a veto over the speaker, it seems to me that just because some folks are strongly against affirmative action doesn't necessarily mean that we shouldn't try to do the right thing.
Thank you. Mr. Levy?
There's no doubt that opposition to race-based admissions has grown, and I think that's because, sort of the justification for it gets further and further in the past. But I agree, it's not really a constitutional argument. But that said, I agree that it does exacerbate racial divisions. I mean, I think the only long-term answer is a colorblind equal protection clause. Otherwise, you're just alternating between what groups society thinks it's okay to discriminate against. It was okay to discriminate against pretty much everyone but white people until 50, 60 years ago, and then maybe at some point, white people and Asian come back and say, hey, now you've been discriminating against us for 50 years. Maybe we deserve some sort of preference, because when our parents went to school, they were discriminated against, and maybe Jews should get a preference. I mean, at the end of the day, should it really just be about disparities, or should it be about who was discriminated against? And Jews were really, really discriminated against. So I think that, anything short of colorblind, and we're just getting into this political game where elite educators or the courts are going to decide against which groups is it now fashionable, permissible to discriminate, and I think that's a dangerous game to play.
Professor Anton, a response?
Yeah, let me come back to Ms. Daskino's question from the other side, if so to speak. I mentioned Fred Gray litigating lots of school desegregation cases. If you look at the experience of the pioneer black students who went to newly desegregated schools, it was not a uniformly happy experience. The Little Rock Nine couldn't get to Central High School without the 101st Airborne, and James Meredith couldn't get into the University of Mississippi without 10,000 federal troops being sent. But I know the lead plaintiff in the Macon County Schools case in Alabama. He used to we worked on a civil rights project together decades ago when we were college students, and we were talking about where we went to high school, and he just casually said, well, I went to 3 high schools. I started in a black school, and then there was a lawsuit, which he didn't say he was the lead plaintiff, but there was a lawsuit. So then I got to go to the white school. But they blew up the white school, so I wound up going to yet a 3rd school. Look at what happened to the students who desegregated Clinton, the high school in Clinton, Tennessee, which was also blown up. I mean, one of the problems that we need to think about is that we have a lot of history. Things may be better now than they were 60, 80, 100 years ago, but when we talk about who's bearing the brunt, right, a lot of times it's the newcomers, the pioneers. And so when we try to do things, we ought to think not only about, well, how do you mollify the opponents, but also sort of how do you protect the beneficiaries, which we have not always been so good at doing.
Thank you both for your responses, and to our panelists for their questions. The speakers will now accept questions from the audience. Please keep your questions concise and respectful.
Okay, so 2 quick comments. One is class-based affirmative action, or class-based preferences might have all sorts of other unexpected effects, including particularly white rural people might possibly be affected by that. So I don't know what the effect would be. I'm wondering for Mr. Levy, it seems that the logic of your case would suggest, for example, that minority contracting preferences, that 10% of the contract should go to companies with sufficient minority ownership, and also mandatory consideration of diversity in hiring for university jobs would seem to be, by your standards, also something that not only is illegitimate, but that the Supreme Court should overturn. What do you think?
Now, I don't know if this was your point, but when I heard you say white rural people, I thought, God forbid, they tend to be conservative. Maybe even in this state. No, I'm not saying you were. That's why I said I don't know what you were thinking, but that's what occurred to me. A lot of people would say that's not the kind of diversity. A lot of people in academia, frankly, don't want I'll use the senator from the state, J.D. Vance, supporters to be what adds diversity. But if you really believed in the diversity rationale as articulated in Bakke and Grutter, then we're talking broad-based diversity, and there is a shortage of conservative students and faculty in academia. And we should
the conservative part. There's a shortage of rural poor people.
Yeah. For sure. I mean, a huge shortage of poor people in academia. So again, I'm sorry, I didn't mean to imply that you were saying that. That's just the first thing that struck me in my mind. That that schools are probably the most insincere entities when they talk about wanting broad-based diversity. That's in many ways the last thing they want if it's really ideological diversity. As for contracting, I think you could make a good case that, and I was involved in some of these lawsuits long ago, challenging contracting preferences, that you shouldn't just be able to assume, under, I think it's 8A and 8B, but basically there's a assumption that if you're a minority, you're economically disadvantaged. Get rid of that assumption, and I have no problem with it, especially in federal contracting, where I think there's been a level playing field, as a matter of fact, and preferences for minorities for a long time. But I don't know if I would get rid of contracting preferences everywhere, because I think there are places where you still have a remedial justification, where you still have an old boys network and contracts are awarded on that basis, and you really can say that if minorities are underrepresented, then then there's a remedial justification for doing away with that. I guess I'm less sympathetic in academia, where I think academia tends to be very elitist, and we're basically talking again about preferences for minorities that grew up in affluent, well-educated families versus whiter Asian people who grew up in affluent families. And I don't think there's much harder for me, at least as a policy matter, to accept that type of reverse discrimination.
But as a legal matter, what are the implications of the Supreme Court's holding?
I think right now virtually nothing. I mean, we'll have to see what the lower courts do. I would have argued that there's a lot of similarity, that the Supreme Court has treated those three areas, employment, contracting, and admissions, very differently. I mean, up until a year ago, you had the diversity rationale in higher education, arguable whether you ever had it in K through 12. In employment, we had very old cases from a much more liberal Supreme Court, which still basically sort of said the diversity rationale was okay. Although, if you remember in the Taxman case, the supporters of racial preferences, gave Sharon Taxman a lot of money to make sure that case ultimately did not get heard by the Supreme Court, because they didn't think it would go as well. And then in contracting, you had Adoran, but I'm not sure anyone really took that seriously. You still had the 8A and 8B programs under the SBA, in which there was an assumption that if you were a minority, you were economically disadvantaged. I think you could make an argument that this as being sort of three almost unrelated areas never really made a lot of sense, but they remain three different areas, and it's not up to me whether they are. It's up to the Supreme Court.
Thank you. I'd like to move on to the next question. I believe we had one here.
I just have some observations, not really a question, but I spent about 40 years working in, for the most part, in pretty selective, affluent private schools, and then I ended up spending about 10 years doing college guidance in a much less affluent situation. And I do think the economics, in my years in the affluent schools, I had some amazing African American students who probably wouldn't have gotten into the most selective schools if it hadn't been for affirmative action, and they succeeded, and that was fantastic. I had one student who's an affluent, happened to be an African American student. His father was a professional dentist or doctor or something, and I didn't think he had the character that many of the others, and he still had the opportunities. He was picked up at the same schools that the African American students who came from relatively modest economic backgrounds, but you can't, discriminate against people because their parents are successful and wealthy. But that was one factor. But I had in my less affluent school, it wasn't sort of getting into the big names. It was getting into a school that the kids were more interested in getting into schools where they can make a difference in environmentalism or dealing with social issues, and not just getting into prestigious banks or law firms or something of that factor. But I had one student who would not have gotten into, she got an amazing scholarship at a state university thanks to my wife, who spent about 2 weeks filling out forms. And it was an opportunity that most students wouldn't have had because they wouldn't have had a counselor who had the time to put that effort into it. But she was just an amazing character, an amazing ability. And because of the effort and the scholarship, she got an opportunity to go to a highly selective state university that wouldn't have happened without that assistance. And then I had one student who was a very affluent, a brilliant Asian American student, but he was applying to highly selective engineering schools, and he got discriminated against by the interviewer because the interviewer asked the student, did you appreciate all the work your parents put into helping you get into these selective colleges, or to financing these selective colleges? And this student basically didn't know how to respond to that because in his culture, parents were supposed to spend their efforts and energies in helping their children succeed in life. And the admissions director wrote a very negative admissions interview, and I was able to respond to the university, and he sort of apologized, and Celeste suggested that he not interview anybody else in the Cleveland area. But there's a lot of injustice out there, but I do think economic and certainly affirmative action with race is certainly a big factor, and is never going to be a perfect solution. What I've been reading about is there are a lot fewer minority students getting into colleges. You mentioned there are slightly fewer in some places, not a huge drop, but I think it will be. Colleges can seem to be no longer use standardized test scores. They can't use racial background, and there are a lot of things. And yet they're giving amazing benefits to athletes, which is.
Excuse me, sir. Is there a question here that we can respond to?
No, my response is that I think I just respond that economics is as important as race.
Thank you. I believe we have some student questions over here I'd like to move to.
Well, I know there's like a lot of intersectionality between race and socioeconomic status, and I see that you have you want to emphasize socioeconomic status, but I also think that in terms of race, there are some things or some effects of race that don't directly or solely apply to socioeconomic status, meaning implicit biases in both the admissions process and the job hiring process. So my question is, and I don't want to misinterpret your sentiment, so that's why I'm asking, but do you believe that we're at a point where the disparities that were created by slavery and the Jim Crow era and things like that have been rectified enough where we can solely look at things from a socioeconomic disadvantage standpoint? Or do you think that we do still need to rectify the effects of slavery and the Jim Crow era, and that affirmative action is not the appropriate way of doing that, and there's a better way to do that?
I mean, I think it's enough generations behind us that we can't just assume that if you have a certain color of skin that you're disadvantaged. But that does not mean, again, that you can't have, when I say, socioeconomic preferences, really any type of disadvantage that you can demonstrate. And the Supreme Court, I think made that clear. So, to the extent that we are affected by discrimination against Jews 100 years ago or against black people, decades ago, I think those manifest themselves in various ways. Less wealth, not the same educational background to your parents, but you can take all that into account. And as I said to you at lunch, when I would debate this, following the Michigan decisions, and I would say to people, do you really think that a black kid who grows up next door to you, whose, father works at the same law firm and they were best friends in college and their house is worth the same, that, that black kid should get 20-point advantage, the difference between an A and a B. And I don't remember even once that somebody said, yeah, I still think they should get a 20-point advantage. Now, maybe a smaller advantage, but like I said, if we were really talking about race being used as one of many diversity factors, I don't think we would have ever had these cases. I think people would have barely noticed.
Thank you. We have a question over here.
Yes. Sorry if I'm misinterpreting what you were saying, but there seems to be a focus on race-neutral and more holistic applications that focus on socioeconomic status and stuff like that. I wanted to quote directly from the dissent of SFFA versus Harvard, where Justice Jackson says, our country has never been colorblind, given the lengthy history of state-sponsored race-based preferences in America. To say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry. I guess my question is, how do you respond to this? What do you think about this? And do you think that it has any basis for legal standing?
Yeah, again, yes, disadvantage can be transmitted, but it doesn't happen by magic. It will show up in, my family isn't as wealthy. I don't live in a nicer house. My father doesn't work for the same law firm. My father didn't go to college. So, again, you can get at this through real disadvantages instead of just assuming that because, I'm a certain race, or in the case of Jews, a certain religion, that, I should get a preference or I should get some sort of deficit. And, a lot of people say what you say is, why should the white or the Asian kid object? But I remember Jennifer Gratz, Barbara Gruder, maybe because she was older, I don't think she took it as personally, but Jennifer Gratz, took it very personally, the fact that she ultimately went to the University of Michigan at Dearborn because Ann Arbor wouldn't accept her, although she, again, if she had been black or Hispanic, she would have gotten in. She felt very stigmatized. I mean, she would always make reference to the fact that I don't understand why I'm being treated this way just because of my race. So I think that it's, just to think that there's no cost for it, psychological or otherwise, I think is just not accurate.
Could I just quickly say something on this? One implication of the majority opinion in SFFA is that students are going to have to try to make themselves seem like they've had all of these burdens that they've somehow had to overcome. Given what I take to be the personal statement industry in college applications, I think that a lot of people who might not want to talk about these sorts of things are going to feel like they have to talk about them because that's all that that apparently is permissible. That's a downside that I think is at least worth thinking about. Just as I think it may be not so easy for an applicant to say, well, I'm a black applicant with professional parents. How are they going to know whether their house isn't as fancy or is worth as much as those of white professionals? I don't know. I mean, it seems to me that the idea that if we're going to make race always, essentially always and everywhere irrelevant, except when applicants think that they need to tug on some admissions office's heartstrings, is not necessarily a good place to be, however it compares to where we were before.
All right, and for the interest of being respectful of everyone's time, that will be our last question. I'd like to invite Mr. Levy and Professor Enton to begin their closing remarks. Mr. Levy, the floor is yours, 5 minutes.
You know, and I'm old enough to remember when there was no personal statement industry. I mean, you know, my parents, well, we were sort of, our high school was came from two different junior highs, and if you came from Herrick's, like I did, then you certainly couldn't afford, you know, SAT courses and a consultant. But even the kids who came from Shelter Rock Junior High School, they didn't have consultants because there was no such thing. So it just strikes me, you know, as I'm thinking about that the advantages of coming from an affluent, well-educated family have only grown since I was in high school, you know, not gotten less. I think that just makes the case for socioeconomic preferences more compelling. And again, it is technically true that you could have both, and that is what they did in up until a year ago in Texas after Hopwood was negated by Grutter. The top 10% program that you had referred to developed its own constituency, and so you couldn't get rid of it. And I would argue it's a constituency much like racial preferences have as well. And so even though they wanted to get rid of it when they could go back to using racial preferences, they didn't. I think they lowered it from 10% to 5%, but they couldn't politically get rid of it. But again, the top 10% on its own did restore racial diversity. But again, so you could have both, but you're not going to, because again, schools don't really like socioeconomic preferences. It is, you know, if I want to take the lowest risk, I'm going to, you know, admit kids from all races, from highly educated families. Certainly admitting people from those families is the best way to ensure that they later give lots of money to the school. So in an ideal world, they could take both into account, but in the actual world, they have to be dragged kicking and screaming. And I can tell you this from, you know, debating this for 20 plus years. You know, they just don't want to do it. The moment that Grutter came down, the schools all wanted to get rid of that top 10% plan. I mean, you know, there were other constituents for it, minorities and poorer whites, but probably the biggest people pushing to get rid of that was the universities. They just, again, for reasons I may not completely understand, they don't want socioeconomic preferences, but that's really what people have in mind. I mean, just take it out of a law school. And when I talk to, you know, just people who aren't lawyers and debate this, there's always a reference to the poor kid. How can you expect the poor kid who grew up in an impoverished neighborhood and, you know, had to deal with gang violence to do as well in the SATs? And that's probably true. It's almost surely true, certainly to some extent, but those kids got really no preference based on that upbringing, and now they're finally going to get a preference, and I think that's a good thing. And will some affluent minority kids be displaced by poorer minority kids, or even, God forbid, you know, poor rural white kids? Yes, but I don't think that's a bad thing, and I'll stop there.
Thank you. Professor Enton?
I want to end kind of where I began. That is, we have a lot of unanswered questions in the wake of the Supreme Court's ruling in the Harvard and UNC cases. We don't know, from the Supreme Court anyway, what counts as race neutral. We don't know from the Supreme Court how far the court's approach will be generalized. But we do know, for example, that efforts to target women and minorities for some kinds of professional and economic opportunities have generated a number of lawsuits, not so much claiming that these programs are unconstitutional, because the programs are not run by governments, they're run by private parties. And the argument is that if you limit eligibility to blacks, Latinos, maybe women, that you're violating federal civil rights laws. So far, lower courts, at least the ones I've seen, have generally been sympathetic to those sorts of arguments. I also want to come back to the point that I made earlier about originalism. As I said, whatever the merits of originalism in general, and that's not our subject today, and I don't mean to suggest otherwise, but whatever the merits of originalism, it's actually quite difficult to make a consistently originalist argument for the colorblind Constitution. And one reason for that is that the 38th Congress that passed the Civil Rights Act of 1866, which was the foundation for the 14th Amendment, and the 39th Congress, which actually approved the 14th Amendment and sent it out to the states, debated those proposals before racially segregated galleries. Moreover, those Congresses approved racially segregated schools in the District of Columbia. Now, there may be reasons, political explanations for why those Congresses did those things. But it seems to me that those facts make it very difficult to make an originalist argument for colorblindness. Of course, originalism isn't the only way to interpret the Constitution. And even the current Supreme Court, which has emphasized originalism and history and tradition in many of its decisions, has not single-mindedly pursued originalism. So I will say, if I had been on the court, I would have dissented in Students for Fair Admissions. But as I also said at the outset, for now, that argument is foreclosed, right? The court has spoken, and the question that we need to think about is, how broad are the implications of this ruling? I don't know, but it strikes me that we're going to see efforts to, beyond the ones we've already seen, to extend this approach to a variety of other settings. And I hope that at least some of those efforts will not succeed, even as I remain a little skeptical about admissions offices in educational institutions for maybe some reasons that Mr. Levy and I might agree on, and maybe for some other ones. But I think I hope we've had a good discussion. I hope that what we have said today has at least been a little bit enlightening, so that wherever you stand on these issues, I hope that you've gotten a little less heat and a little more light. Thank you.
And feel free to ask me questions afterwards if you have any.
Sure. Well, thank you both. I would like to now invite Ms. Feng to deliver her closing remarks.
Ladies and gentlemen, the Society for Constitutional Policy members express our most sincere appreciation to Mr. Levy and Professor Enten for joining us today. We give special thanks to the Office of the President and the Provost for their support. We would also like to thank our many contributors without whom this event would not be possible: the School of Law, the Department of Political Science, the Center for Policy Studies, the Federalist Society, our student panelists, moderator, timers, and volunteers, and our wonderful advisors, Professor Locker, Professor Chodakov, and Dr. White. Thank you. We wish you a great rest of your night, and we invite you to join us for a reception upstairs in Ben's place.